Good morning to all of you. Welcome to Legal Matters by Sai Babu Tinkara. In this video, we are going to discuss regarding the evil attempt of handcuffing. Normally, handcuffing, as advocates, normally you don't relish. And Supreme Court guidelines are there. It is anti or against to the personal liberty of any individual as envisaged in the Article 21 of the Constitution of India. Please remember, already famous case, Prem Shankar Shula, Punjab case. Prem Shankar Shula versus Delhi administration. There clearly it was stated by the Supreme Court that handcuffing of prisoners either by the police or the jail authorities. So they do not have any authority except with the permission of the High Court. Right? Please remember. Because it is personal, almost it is against the dignity of the person. So that is the version of the Honorable Supreme Court and High Courts also. Prem Shankar Shula is the decided case law in this particular cause. Likewise, I think in 1996, INRI, MP, Dwivedi and 6 others. You can read the citation as SCC page number 152 in volume number 4. Right? Handcuffing of prisoners is highly deprecated even though they were connected. Whether they are convicted or whether they are under trial prisoners, handcuffing is not allowed. Right? So then, now coming to the point of the police, why they handcuff the persons? What are the authority? Yes, they can handcuff the persons normally. So I have taken a resolution, that is Police Manual of Madhya Pradesh Police, because INRI, MP, Dwivedi, this case relates to Madhya Pradesh. So Madhya Pradesh regulation number 465, it says, it gives a list of the persons who can be handcuffed if they are dangerous to the society. Number 1, the persons involved in offences relating to section 231 to 234, that is coins and currency. Old cases nowadays, such persons are not there. Leave it. Second issue, section 302 to TO2, 304, that is murder, culpable homicide. So all these things. Even next stage comes section 307 and 308. Even attempt to murder also, such persons can be handcuffed. Then section 311, that means belonging to a group of robbers or being a thug, I can say. Then 395, dacoity case. And persons who are convicted previously in property, that means thieves, they may escape. If they escape, there is no chance of catching them. For those persons, yes, the police can handcuff. But as a thumb rule, police cannot handcuff anybody after arrest. For arrest, yes, they can handcuff him. After arrest, once they are coming to custody, maybe police custody, maybe judicial custody. Once they come to custody, they cannot, the police have no authority to handcuff them. Right. Here, suppose if he escapes, police question will be like this. If he escapes, who is going to take responsibility? Same question we asked the judge. He said, yes, we are going to issue a warrant, you can go and arrest him. So that is the reply from them. Law says like that, we can't help it. But here, please remember, the defense points also better to understand. Whether the court, here in this case, the court did not accept, but as a defense advocate, suppose if any such issue comes, you have to be ready with the defense. The defense points are: number 1, the accused are large in number, they are 7 in number, and they resisted the arrest. Actually, they tried to resist the arrest, they tried to escape from the place. So, they tried to escape. In such a cases, what can we do? Handcuff. Number 2, large number of supporters gathered there, and there is a likelihood of taking away the persons, or there is a likelihood of these persons merging with them, or there is a likelihood of escaping also. Is it not? So, in such cases, if they escape from the police custody, definitely it will be an offence under section 224 of the Indian Penal Code. Is it not? You all know 224. So therefore, we have to handcuff him. This is the defense. Of course, whether it is acceptable or not. So in this connection, Supreme Court in Prem Shankar Shula case clearly given directions. No doubt, Police normally, when you are producing any accused person before the court, don't handcuff him. It is against his personal liberty. Suppose if he is a thug, if he is a dangerous person, if he is our Munna Bhai, then what are you going to do? Yes, you take permission from the court and handcuff him. Court is there to give permission. In extraordinary circumstances, suppose if a criminal is there, if a dreaded criminal is there, he has to be brought from Nellore, then court will ask you to send strong escort. What does it mean? An SI will be there. Likewise, if you request the court, definitely they will give permission for you to handcuff him. Otherwise, you should not handcuff him. Why this problem has come? I will give a live example. It may take some more time. So, what happens is, suppose if a person is there, if the police if they are under the apprehension that he will run away, normally they will tie his hand to the lockup or something like that. So if at all his relatives come, how do they feel? So now the police will bargain with them. Of course, that is a secondary aspect. Whatever it is definitely defamatory, undignified to the prestige of an unknown person. So why I am all this telling all this, once again I am telling is, very recently on 10/6/2022, in the case of Suprit Ishwar Divate, actually he is a lawyer or law student. So versus in the case of Suprit Ishwar Divate versus state of Karnataka in WP number 115362 by 2019. So on 10/6/2022, Karnataka High Court, single judge, Suras Govindaraj, he has actually ordered compensation of 2 lakhs to this law student, or to this lawyer, I'm sorry. I don't know whether he's a lawyer or a student. So what happened is, this happened in Chikkodi of Belagavi district. Belagavi, maybe Bellary, I don't know. Belgaum, maybe Belgaum district. So what happened is, this man is having 4 cases against him, out of which one is a negotiable instrument act. So as per section 130 of the NE Act, an NBW was given against him. The NBW has been executed. So while producing or while taking him to the court, actually he was handcuffed and put in the so-called bus. So the van which takes the people to the court. So this photograph was taken, and some constable used some nonsensical language. That was also recorded. Then before the magistrate, he has clearly stated that he was handcuffed. This was taken as a contempt. Then they have initiated the inquiry. So ultimately the inquiry, actually they has filed a writ petition also under Article 226. An inquiry was conducted. If the videograph is clear that this man was handcuffed. Another allegation by this man is that he was paraded, but of course the parading was not at all seen in the video. That was not, that was thrown out. Only thing is, the person, a lawyer, was handcuffed. So therefore, the High Court took it very seriously and awarded a compensation of 2 lakhs to the petitioner lawyer. So this is the thing which is going to happen if the police handcuffs a person. Very good case. 3 cases, please remember. Prem Shankar Shula, Inri, MP Dwivedi, another 1996. And now, latest case is, this is Suprit Ishwar Divate versus state of Karnataka. Right? If you remember these cases, this is sufficient. Important issue, handcuffing, definitely it is against to Article 21 of the Constitution of India. Okay, thank you very much.